Do not volunteer to be an indentured servant. The nature and meaning of 26 CFR Sec. 31.3402. The federal withholding system, often misunderstood and rarely scrutinized, carries far-reaching implications for individual liberty, economic autonomy, and the boundaries of consent in taxation. While the term voluntary evokes freedom of choice, the machinery of tax withholding appears to blur the lines between agreement and coercion. This article seeks to illuminate the true nature of voluntary withholding agreements under 26 CFR Sec. 31.3402, examining its statutory and regulatory underpinnings. We challenge whether the American workforce inadvertently consents to a form of modern-day economic servitude by misinterpreting what the law explicitly provides. The origin and mechanics of voluntary withholding agreements. Section 3402P of the Internal Revenue Code, implemented via 26 CFR Sec. 30.3402, establishes a critical yet overlooked concept. Income tax withholding agreements are, under law, voluntary. Specifically, under subsection B, an employee who wishes to have income tax withheld furnishes their employer with a Form W-4. This form, submitted as a request, initiates a legal agreement to withhold taxes. The relevant text of 26 CFR Sec. 31.3402 P1 states, an agreement under Section 34.2P shall be effective for such period as the employer and the employee mutually agree upon. However, either the employer or the employee may terminate the agreement prior to the end of such period by furnishing a signed written notice to the other. Critically, this language clarifies 2 points. 1. Mutual agreement. Withholding does not occur absent the mutual consent of employer and employee. 2. Termination clause. Either party may end the agreement at any time through written notice. The very structure of the regulation frames withholding as a bilateral contract, not a mandatory obligation for all employees. 2. The legal definition of employee. Unpacking Section 3401C. To demystify the scope of tax withholding, we must first identify who qualifies as an employee under federal law. Section 3401C offers a restrictive definition. The term employee includes an officer, employee, or elected official of the United States, a state, or any political subdivision thereof, or the District of Columbia, or any agency or instrumentality of any one or more of the foregoing. The term employee also includes an officer of a corporation. 2 observations emerge. 1. Scope of employee. The language of 3401C narrowly limits the definition to public officials, officers of corporations, and specific government employees. The inclusion of the word includes further signals that the list is exhaustive rather than illustrative. 2. Private sector workers. Notably absent from 3401C are private sector workers who constitute the vast majority of the American labor force. This raises a provocative question. Are private sector employees who sign a W-4 doing so out of statutory obligation, or are they unwittingly volunteering? 3. Voluntary withholding. The contractual nature of consent. Section 3402P and its regulatory framework hinge upon principles of contract law. For a withholding agreement to be valid, it must satisfy the basic tenets of consent: offer, acceptance, and consideration. The Form W-4 functions as the employee's request, offer, and the employer's act of withholding constitutes acceptance. However, the law preserves the individual's autonomy in 2 critical ways. Request versus requirement. The regulation frames withholding as a request rather than a mandated obligation. Submitting Form W-4 is not compulsory. Right to terminate. Employees maintain an unambiguous right to end withholding agreements at any time. These provisions emphasize that individuals retain control over whether income tax is withheld from their wages. Yet societal norms and administrative practices obscure this reality, leading many to believe withholding is compulsory. The modern implications: coerced compliance and economic subjugation. Despite the plain language of the statute, pervasive misconceptions surrounding income tax withholding have enabled systemic overreach. The IRS and employers often fail to clarify the voluntary nature of W-4 submission. As a result, workers unknowingly forfeit their right to retain their earnings in full until tax liability is proven and assessed. This raises broader concerns. 1. Economic servitude. By signing a W-4 without full understanding, workers may unwittingly enter into a form of economic servitude. The regular seizure of wages through withholding shifts the burden of proof from the government to the individual. 2. Knowledge gap. The absence of informed consent perpetuates compliance. Workers rarely exercise their right to terminate withholding agreements due to fear, ignorance, or pressure. Legal and policy recommendations. To restore the voluntary nature of tax withholding and uphold principles of consent, we propose the following reforms. 1. Mandatory disclosure. Employers should be required to inform workers, in writing, of their right to decline or terminate a withholding agreement under 26 CFR Sec. 31.3402 p. 2. Clarification of employee. The IRS should issue guidance clarifying the statutory definition of employee under Section 3401C to prevent overreach. 3. Worker education. Educational initiatives should empower workers to understand their rights and obligations under the tax code. Conclusion. The regulatory language of 26 CFR Sec. 31.3402 p. and the statutory definition of employee under Section 3401C reveal a striking reality. Income tax withholding is a voluntary agreement, not an inherent obligation. Yet, through misinformation, administrative inertia, and societal norms, the workforce has been conditioned to submit to withholding without question. By reframing this issue within the principles of consent and economic autonomy, we challenge individuals to reclaim control over their labor and earnings. The law, as written, offers a path toward economic freedom, but it requires individuals to assert their rights and decline to volunteer for modern economic servitude. Do not volunteer to become an indentured servant. The law offers you freedom if you choose to exercise it.
A worker's toil, both sweat and grace, should not be taxed at breakneck pace. For here the law in plainest script has freed the man whose chains were clipped. An employee the rule confines to state and those of corporate lines, and private souls with wills unbent need not succumb to servitude's rent.